is a aspect which has caught, I would say, off late quite often. And the validity, the purpose, the authority, and the format are some of the aspects which lawyers, students of law, professionals, and those who come out with the lookout circulars is an aspect which would always want to learn. And the interesting facet of law is that you always evolve yourself as a lawyer and as a professional. And the more you feel that you are a student of law, that is they say that it is the ultimate success mantra, that as you keep on learning, you keep on improving yourself. Being a weekend, I would request Vikram to introduce the topic as such, and then we will ask Mr. Vikram to share his knowledge. Over to you, Vikram.
Yeah, very good evening to Senior Advocate Mr. Vikram as well as Vikas sir. Once again, thank you from my end for this collaboration, and many thanks to Mr. Vikram Huilgol, Senior Advocate, High Court of Karnataka, for accepting our invite. I would like to just make a mention about the commendable job that the Senior Advocate had done, especially during the second phase of lockdown, when we're all in a very bad situation. He was in the Court Hall 1 before the Honorable Chief Justice. And he was the key person who has got us many help, especially during the pandemic situation, may it be the oxygen or many such cases. It was Mr. Vikram. And he has also, he was appointed as the amicus because there were so many petitions which were filed. And that point of time, Mr. Vikram was appointed as the amicus, and he had to literally assist the court by going through those petitions and making submissions. And most relevant petitions were those were listed as the public interest litigation, just to reduce the unwanted petitions, which were filed. So even in the capacity of the amicus, he has assisted the court immensely. Once again, many thanks to Mr. Vikram. I would not take much of the time. Before, over to you, Mr. Vikram.
First of all, thank you, Mr. Vikas and Mr. Trivikram, for having me on this platform. I'll be honest, I've been a keen follower of this platform. I have been watching a number of the videos that have been uploaded on YouTube. And so when Trivikram asked me whether I would be willing to speak, I didn't have to even think for a second. And I was absolutely overjoyed and privileged that they asked me to share my views on this August platform. That's number one. Number two, I'd also like to thank both Mr. Vikas and Mr. Trivikram for their very lavish praise. I would say some undeserving. We were in a very difficult circumstance then, and I was very frankly just fortunate that I was given the opportunity to assist the court in such a difficult time. So thank you anyway for the very lavish praise. So over to the topic for today. When Mr. Trivikram and Mr. Vikas in particular asked me what I'd be willing to speak on, usually, I'll be honest, when people ask me to speak, it's generally with regard to some GST related topic or customs or excise or some tax related issue. I thought maybe the recent 148A order passed by the Supreme Court. But I was pleasantly surprised when I said, when I suggested, would you like me to speak on something about tax? Mr. Vikas immediately said, no, could you think of something else? And I just thought about it for maybe a couple of days, and I thought, as Mr. Vikas rightly pointed out, these lookout circulars have suddenly become have become very popular / unpopular of late, depending on which side of the fence you are on. And they've been highly litigated, highly publicly litigated, because there have been some quite prominent personalities who have been the subject matter of these lookout circulars, and matters have been taken up to various courts. So we keep reading about them in the media, and frankly, I had very little idea about what these lookout circulars are. So then I did some work, did some research. I also I had the opportunity to assist the Karnataka High Court in one of these LOC cases. So that's when I thought, okay, this would be an interesting issue. I had built a certain amount of database on this, and I put myself in the shoes of most. This is not in any way derogatory of any of the persons who are on this platform watching this, but I thought a large majority of the people know about lookout circulars only from the media. And let's be honest, what we read about these lookout circulars in the media is very, it just touches the surface. It doesn't go in depth into the subject, what these lookout circulars are, how they're regulated, and so on. So I thought this would be a good platform to share the little bit of work that I've done. Of course, there is an ocean of information out there on lookout circulars, and given the limited time we have, what I thought I would do was broadly classify what I would talk about these lookout circulars into. First, of course, broadly speaking, what is a lookout circular? Then what is the legal basis for this lookout circular? Is there any statutory framework for these lookout circulars? Then when can these lookout circulars be issued? In what circumstances can they be issued? Against whom can they be issued? Then, of course, the slightly drier aspect of what is the procedure, but it's equally important, because if these lookout circulars are issued, as practitioners, we all know that if there are certain flaws in the procedure, in the procedural aspect, they can certainly be a ground for challenge before the appropriate court. So I'll just touch upon the procedure for issuance of these lookout circulars. Who can actually issue these lookout circulars? That also is important. Not everyone can issue these lookout circulars. The duration for how long these lookout circulars can be kept valid. And of course, most importantly, as legal practitioners, what are the remedies against these lookout circulars? Are they a subject matter of judicial review? How do we get these lookout circulars, if required, quashed or withdrawn, or so on? So this is broadly how I thought I'd structure the next hour or so on the topic. So diving straight into the topic itself, what is a lookout circular? And this is, of course, just a very, very bird's eye view of what a lookout circular is. And I'm quoting from some judgments, which I will extensively deal with over the next hour or so. It very, very, very briefly put, it's a coercive measure to restrict and regulate the entry and departure of persons into the territory of India. So if somebody wants to leave India, if a lookout circular is again issued against him or her, there is a restriction on that person leaving the shores of our country. Of course, they are subject to various restrictions. It cannot be issued at anyone's whim or fancy. Initially, it was intended only for persons who have been accused of cognizable offenses, who are facing trial, who are subject matter of an investigation, a cognizable offense. But I'll also deal with how that has been enlarged to almost disproportionately, and how it's not restricted anymore only to cognizable offenses, and how it's far broader in scope as on today. So suffice to say for the moment that it's a coercive measure. It's a restriction on the person's ingress and egress into the country. And yes, it is issued by a state or a central government authority by way of an executive order. So that is very briefly speaking of a bird's eye view of what a lookout circular is. So what is the legal basis? That was the first question I asked myself. When I first read about these lookout circulars, I said, okay, are they issued under some act? Are they issued under the CRPC? Are they issued under any particular act? The answer, very, very simply put, is no. They have zero statutory basis. In fact, courts have, I'll deal with some of these judgments, courts have dealt with the aspect of how these lookout circulars can be issued without any statutory basis. They are not grounded in any legislation whatsoever. They are governed by various executive instructions. issued by the Ministry of Home Affairs, central government, from time to time. Initially, it was governed by a letter of the Ministry of Home Affairs dated 5th of September 1979. Then it was superseded by an office memorandum in the year 2000. Then, interestingly, there were a couple of landmark judgments, both of the Delhi High Court. I'll deal with those judgments also. One is in the case of Vikram Sharma and one in the case of Sumer Singh Salkan. I'll deal with those cases, so no need to note them down immediately. But because of those two judgments and because of certain observations and directions issued in those two judgments by the Honorable Delhi High Court, the Ministry of Home Affairs issued a consolidated office memorandum in the year 2010, more specifically on 27th of October 2010. That has been the basis for the issuance of these lookout circulars. There has been a subsequent office memorandum, not really changing much in the 2010 office memorandum, but adding some more conditions, adding some more circumstances in which these lookout circulars can be issued. This was done in 2017, which has subsequently been amended as recently as on 22nd February of last year, 2021. And again, there's another corrigendum of 10th of August, 2021. I'll be honest, I did a lot of research on the internet to get these office memoranda out. The information out there is very, very sparse. The 1979 circular is not available. The 1979 letter is not available. The 2000 office memorandum is not available, but there are certain images of that available on certain websites. So all of this I have got from judgments of various courts, because when lookout circulars were issued and they were challenged in various courts, in the Delhi High Court or even in Karnataka High Court, the courts have extracted portions of this office memorandum, of these office memoranda. But yes, why I'm saying this is, if tomorrow you want to Google this or check on the internet or check on any particular website, even on the Ministry of Home Affairs website, to the best of my knowledge, none of these office memoranda are publicly available. But of course, they are not secret documents because they are, like I said, they're extracted extensively in some of these judgments. So this is how I've culled out most of these clauses. So again, as I was saying, there is no statutory framework for it. These lookout circulars are governed by these office memoranda. So the next aspect is, since they are governed by these office memoranda, the office memoranda themselves set out when an LOC can be issued and in what circumstances they can be issued. Who can they be issued against? When, in what circumstances? The 1979 letter, from what I could find in some judgments, was very, very vague. It was just a power that was granted to various authorities, including the Income Tax Department, the Department of Revenue Intelligence, Customs Department, where they could restrict this movement. It did not specifically set out in what circumstances it could be issued and so on. And the 2000 office memorandum sort of made it a little more elaborate, but once again, it was quite lacking in the regulatory framework. It was not really regulated in the manner in which it should have been. So that's why I'm coming to the first judgment. I said there were two landmark judgments of the Honorable Delhi High Court, both in the year 2010. So 1979 till about 2010, it was, so to speak, very, very loosely regulated. Not too much, possibly there are not too many judgments during that period also, because they were not really often used, like subject to correction. Possibly they were used, possibly they were not litigated as much, possibly these judgments are not as publicly available as the more recent judgments. 2010 onwards, there has been a flood of litigation on lookout circulars, which is why the bulk of the information out there is 2010 onwards. The first judgment I was referring to is the case of Sumer Singh Salkan versus Assistant Director. It's reported in ILR 2010, Volume 6, Delhi 706. There were various issues. Time will not permit me to go into the facts of each of those cases, but one of the issues framed before the Delhi High Court is precisely that that what are the categories of cases in which the investigating agency, whichever agency it might be, can seek the recourse of an LOC and under what circumstances. So till 2010, that was not really very clear. In what circumstances can an investigating agency seek the opening of an LOC against a subject? And if I may quote, what the Delhi High Court in 2010 said was, recourse to an LOC can be taken by an investigating agency in point number one, in cognizable offenses under the Indian Penal Code or other penal laws. 2, where the accused was deliberately evading arrest or not appearing before the court despite NBWs. And 3, there was the likelihood of the accused fleeing from the country to evade trial or arrest. So in the absence of any regulatory framework, the Honorable Delhi High Court itself came forward and framed the question, in what circumstances can an LOC be issued, and answered the question by giving these 3 points. 1, it has to be in relation to a cognizable offense under the IPC or any other penal law. 2, the accused has to be deliberately evading arrest. And 3, there is the likelihood of the accused fleeing from the country. These observations of the Delhi High Court necessitated the issuance of the 2010 official office memorandum. And that has not changed, this basis for the issuance of LOCs and in what circumstances it can be issued. That has not changed since 2010. As I was saying sometime earlier, it's been, the circumstances have been broadened quite vastly. But these 3 circumstances have remained the same from 2010 onwards till now. So in fact, the 2021 office memorandum, which again I could pull out because of certain judgments, it says that recourse to an LOC is to be taken. This is the Ministry of Home Affairs. This is a direction which would necessarily be binding on all the investigating agencies as well as the Bureau of Immigration. And again, I quote, the Ministry of Home Affairs says recourse to an LOC is to be taken in cognizable offenses under the IPC or other penal laws. So therefore, they copy pasted pretty much verbatim what the Honorable Delhi High Court said. And importantly, they said the reasons for the request. So if the investigating agency is the NIA or the Enforcement Directorate, whoever, or the CBI, whoever it may be, the reasons for the request must be provided, without which, this is in the office memorandum, I quote, without which the subject will not be arrested or detained. Therefore, there is the important safeguard which is built within the office memorandum itself. In that, 1, of course, it has to be in relation to a cognizable offense. And 2, there must necessarily be reasons provided without which the subject cannot be arrested or detained. All well and good. In fact, it's made even more amply clear in the very next paragraph. It says, in cases where there is no cognizable offense, the LOC subject cannot be detained or arrested or prevented from leaving the country. And in such cases, the originating agency can only request that they be informed about the arrival or departure of the subject. So here there is a strong procedural safeguard to ensure the rights of the citizens built in within the office memorandum itself. As I was saying earlier, the reasons have to be recorded. It has to be in relation to a cognizable offense. And very clearly, the instruction is, if there is no cognizable offense, you cannot arrest or detain him. He must be permitted to leave the country. However, the dates for departure and arrival, those can be ascertained at best. Again, it appears at this stage that where is the problem really? I'll come to that. In fact, these have been repeatedly reiterated in various judgments, including the Honorable Karnataka High Court, in a judgment in CBI versus Asif Kadir. This is criminal petition number 1479 of 2021, decided recently on 25th of June 2021, where the Honorable Karnataka High Court, I quote, said, recourse to an LOC can be taken only when the accused is deliberately evading arrest or not appearing in the trial court, and if there is a likelihood of the accused traveling abroad and trying to flee from justice. The LOC can be issued only as a coercive measure to make a person surrender, cooperate, or with the investigation agency or with the court. So therefore, there are sufficient procedural safeguards which have even been recognized by the courts. Therefore, not only should he be accused of a cognizable offense, there also has to be a reasonable likelihood that he is trying to flee from justice, flee from being arrested or detained. And only if those circumstances are prevalent can an LOC be issued, failing which it is liable to be quashed. Of course, there is the famous judgment of Karti Chidambaram as well, which was decided by the Madras High Court in WP number 21305 of 2017, 21305 order dated 23rd July 2018, where Madras High Court has very, very clearly said that there should be sufficient basis for the issuance of a lookout circular, and the conditions precedent to issue such a notice must be satisfied, particularly since the issue of an LOC is a coercive measure. This was again followed recently in the most in the case of Rana Ayub, which was quite widely reported just a couple of months ago, in the Delhi High Court judgment dated 4th of April 2022, where referring to the judgment in Karti Chidambaram, the Honorable Delhi High Court has once again reiterated that the conditions precedent in the office memorandum as well as the judgments of the courts must be satisfied before any lookout circular can be requested or be issued. So therefore, over a period of time, there have been a fair number of procedural safeguards that have been evolved to protect the citizen from an arbitrary action of the state. But here starts the problem. The problem starts with the 2010 office memorandum itself, but the real problem is in 2017 and 2021, where the Ministry of Home Affairs went way beyond the observations of the Delhi High Court in Sumer Singh Salkhan, where very clearly it said issuance of an LOC can only be in circumstances of a cognizable offense or where he is trying to flee from justice and so on. In the 2010 office memorandum, an exception to this rule was carved out in respect of terrorists, anti-national elements, etc., in the larger national interest. That can, as we all know, be very, very subjectively construed by the authorities. If, of course, a terrorist, it's a very hard, it's a very strong term, but an anti-national element can be very, very subjective. And if it says anti-national element in the larger national interest, certainly it gives a lot of discretion in the hands of the investigating agencies to request issuance of these LOCs. But 2010, again, this was, the exception was fairly small, if I may say so, although this can be very broadly construed. This anti-national element was the subject of adjudication before the Delhi High Court in the case of Priya Pillai. This is a 2015 judgment. I'll come to that a little later on a different aspect, but I don't want to dwell too much on how the Delhi High Court dealt with this anti-national, because that will go outside the scope of this particular discussion today. But suffice to say that up to 2017, the rule was cognizable offense, trying to flee from justice, and the exception was, however, despite that, in exceptional circumstances, if in the larger national interest, a lookout circular can be issued. Then in 2017, the scope was broadened even further and said in exceptional circumstances, LOC can be issued, this is important, without following these guidelines. Therefore, they said, we don't need to follow these guidelines. We don't need to follow the guidelines where there has to be a cognizable offense. In a case where there is no cognizable offense, he need not be arrested or detained. So you dehorse these guidelines, and LOC can be issued, one, where the departure of the person is detrimental to the sovereignty, security, or integrity of India. Again, very broadly couched, that the departure is detrimental to the bilateral relations with any other country. This is extremely important, the third point, that it is detrimental to the strategic or economic interests of the country. Why I said this is important is because this economic interest of the country has been invoked in a number of cases and which has been the subject matter of adjudication in a number of courts. So what I'm trying to say is the scope was broadened tremendously. Initially, it was meant for a very, very specific purpose. Then, by saying that the departure is in the larger national interest, it was slightly broadened. But then by saying that departure could be detrimental to the strategic or economic interest of the country, it was virtually, you're opening up the floodgates. And the last one is, if that is the floodgate, it completely breaks the dam itself and says that the departure ought not to be permitted in the larger public interest. So the office memorandum of 2017 went way beyond the initial observations of the Delhi High Court in Sumer Singh Sarkar and said, in exceptional circumstances, of course, it says in exceptional circumstances, without following the guidelines, if the subject of the LOC could be said to be detrimental to the larger public interest or economic interest of India, even then a lookout circular can be issued. Now that is where the problem really started, because when so much discretion, as we've seen over the last 70 odd years of independence, when so much discretion is placed in the hands of executive authorities, it is quite often subject to abuse. It can be used as a tool of harassment, as repeatedly in the recent past, in the last 1 year, we've seen where courts have come down heavily on these agencies, saying that you cannot harass people. And with these conditions prevalent, there is certainly, I'm not for a moment suggesting that it is every case where the executive oversteps its bounds. Having appeared extensively for the government myself, I possibly don't have the locus to say that. But it is certainly, without any cavil of doubt, a tool by which potentially a person, a citizen, can be harassed extensively by the executive authorities. In fact, in a very, very recent judgment of the Delhi High Court, again, in the case of Vikas Chaudhary versus Union of India, the judgment dated 12th of January 2022. It's reported in 2022 SCC Online Delhi 97. I'll quote what the Honorable Delhi High Court said. Merely because the office memorandum permits the issuance of an LOC in exceptional circumstances, even when the individual is not involved in any cognizable offense, it has to be remembered that this power is to be used in exceptional circumstances and not as a matter of routine. It must therefore be interpreted in a manner that indicates an offense of such a magnitude so as to significantly affect the economic interests of the country. And mere suspicion cannot be accepted as the basis for holding that the petitioner being allowed to travel abroad would be detrimental to the economic interests of the country. There again, without going into the facts, the clause invoked for issuance of LOC in that particular case, in the case of Vikas Chaudhary, was that the person's departure from the country would be detrimental to the economic interests. And the Delhi High Court came down very heavily, saying that you can't construe this economic interest so broadly so as to curtail his fundamental right of traveling abroad. And this clause should be used only in exceptional circumstances where it significantly affects the economic interest. Now, again, that also is a very subjective matter. Now, what is significantly affects? If it's 100 crore, say it's a tax evader, say he has not paid 1 crore of tax, is it significantly affecting the economic interest of the country? Or if it's 1,000 crore scam, alleged scam, is it significantly affecting? So the courts would necessarily have to step in each of the cases, examine the facts and circumstances, and then decide the validity of these LOCs. There's another very good judgment of the Honorable Delhi High Court in the case of Deep Sarup Agarwal, 2020 SCC Online, Delhi 1913, judgment dated 2nd of December 2020, where again the issue of economic interest of the country arose. And the Delhi High Court said the reasons for opening of the LOC must specifically state. So the reasons for opening the LOC must specifically state in what manner the departure of the subject would prejudice the economic interests of India. So it merely saying that yes, his departure would affect the economic interests of India would not be sufficient. The reason must specifically state how it's going to affect the economic interests of India. And also, in another judgment, once again, all of these are Delhi High Court judgments. In the case of Brij Bhushan Katuria, 2021 SCC Online, Delhi 2587, judgment dated 15th of April 2021, where the Delhi High Court again said where the role of the subject is yet to be ascertained. So there's no real role that has been ascertained with regard to the subject of the LOC. Phrases such as economic interests of India and larger public interest cannot be expanded in such a manner so as to include persons against whom no specific role has been attributed to that person. So the courts have repeatedly stepped in to ensure that the executive authorities do not overstep their bounds in invoking these various clauses, larger public interest, economic interests of India, and so on, and have, by way of judicial activism, have evolved various safeguards to ensure that the executive authorities do not abuse the power that are vested in them. Then, of course, I think there is one aspect which I forgot to cover. Just in the 2021 office memorandum, it seems to have been, I think it is a little later. There is, yes, under the 2021 office memorandum, it's important to note, I'll cover that in little more detail later. But this larger economic interest of India was already quite a vexed issue. It became even more vexed when the power to request issuance of an LOC was given to the chairman / managing director / chief executive of all public sector banks. So here we see how it was further broadened. Initially, it was just a certain number of investigating agencies, statutory authorities who could request issuance of these LOCs. Now, when this economic interest of India concept was brought into these office memorandum, then the power was also given to chairmen of public sector banks. So I'll deal with that a little later, but just to point out how the scope of these lookout circulars is consistently being broadened over a period of time. Then, of course, as I was saying, another procedural safeguard that has been built in is the mentioning of reasons. The office memorandum itself says so. Why the courts had to step in is, as I was saying, in these exceptional circumstances, which are the exception to the general rule that it has to be in the case of a cognizable offense. The wording is that none of these guidelines would be applicable. So the question was, in such circumstances, do you need reasons? And the answer quite simply is yes. When executive authority is being exercised in such a manner so as to potentially infringe fundamental rights, courts have repeatedly held that there have to be reasons that have been ascribed, and mere apprehensions and suspicions are not sufficient. So there have to be concrete reasons as to why such a drastic coercive measure is required. And in the absence of which, in fact, although the judgment in Karti Chidambaram is quite extensive, the judgment could have stopped possibly 5 pages earlier itself, because one of the observations is that there are no reasons forthcoming in the lookout circular, and on this ground alone, the writ petition is liable to be allowed. So therefore, the judgment could possibly have ended there, but of course, they went into the broader aspects of whether circumstances were the issuance of LOC was justifiable, whether the economic interests of India were really affected, and so on. But the courts have repeatedly held that in the absence of reasons, a lookout circular is simply not sustainable. And again, very, very important, mere evasiveness. Now, let us say someone is the subject matter of an investigation, and the investigating authorities of the opinion that he is not given sufficient answers, he is being a little evasive in his answers, and so on. In the same judgment I mentioned, Deep Sarup Agarwal, the Delhi High Court came down heavily again and said the reason for opening an LOC cannot be merely that the subject is not cooperating or being evasive. So there has, essentially what the courts have consistently held is that there have to be certain reasons beyond just non-cooperation or being a little evasive. So since you're adopting such a drastic measure, there have to be sufficient justifiable reasons, failing which an LOC would be the subject matter of judicial review. Duration of an LOC is very simple. I won't take more than a minute. Consistently till 2021, all these office memoranda, the duration of the LOC was 1 year, after which the LOC itself would lapse. But in 2021, the latest office memorandum, that clause has been removed. And there is no automatic deletion of an LOC as per the 2021 office memorandum. And unless there is a specific letter by the investigating authorities to the Bureau of Immigration, that LOC will be valid. However, annually, that LOC should be reviewed, whether the LOC is necessary or not. It should be the matter of a review, and that's about it. So therefore, duration has been completely done away with in the latest 2021 office memorandum. So then the next aspect is, who can issue this LOC? Can it be issued by any agency? Can the Enforcement Directorate issue it? Can the CBI issue it? Those are questions which arose over a period of time. Initially, the answer to that was yes. As per the MHA letter of 1979, the Income Tax Department, Customs Department, Department of Revenue Intelligence, CBI, State Police, anyone could request, not request, could actually issue the lookout circular, and then the communication would be sent to the department or the Bureau of Immigration, in which case his or her movement would immediately be restricted. Then under the 2000 office memorandum, the power was completely vested in the Bureau of Immigration. However, at the request of one of the investigating agencies, in fact, the wording used is originating agency. Now, again, it was not clear who were all these originating agencies, other than it just said Deputy Secretary to the Government of India, Joint Secretary in the state government, concerned Superintendent of Police at district levels. But of course, other agencies also could request. It was not formally delineated as to who could request these lookout circulars. As a result of which, a peculiar circumstance arose in the case of Vikram Sharma. In fact, I mentioned right in the beginning, there were two judgments of the Delhi High Court, one in Sumer Singh Salkar and the other judgment in Vikram Sharma, which necessitated the issuance of the 2010 office memorandum. In Vikram Sharma, what happened was that there were certain statutory bodies such as the National Commission for Women, the National Human Rights Commission, and so on, who were requesting issuance of these LOCs. And because none of this was really regulated in the 2000 office memorandum, LOCs were routinely being issued at their behest. The Delhi High Court came down on that and said, sorry, not everybody can request the issuance of these LOCs, even though these are statutory bodies. They are not investigating agencies. They are not investigating into any crime, so to speak. And therefore, a direction was issued to the Ministry of Home Affairs to specify who these investigating agencies should be. And only those investigating agencies should be empowered to request the issuance of these lookout circulars. So therefore, the Delhi High Court directed the Ministry of Home Affairs to clarify that if such agencies want to request for opening of LOCs, they must bring the necessary facts to the concerned law enforcement agency. So anybody outside of these list of agencies who can request issuance of LOCs, their only option was to approach an investigating agency and place the necessary facts before them and say, this is why an LOC is required. So therefore, kindly write to the Bureau of Immigration to issue this LOC. As per the direction of the Delhi High Court, the 2010 office memorandum came out with an exhaustive list of persons who could write to the Bureau of Immigration to issue an LOC, and that request also should contain reasons as to why an LOC is required. I won't read through all of these, but some of the important agencies would be Deputy Secretary to the Government of India, Joint Secretary to the State Government. So Union of India, State Government. then the district magistrate of the district concerned, SP in the CBI, then zonal director of the Narcotics Control Bureau, deputy commissioner or equivalent rank in the Directorate of Revenue Intelligence, Central Board of Direct Taxes, Central Board of Excise and Customs, which is now Central Board of Indirect Taxes and Customs, Intelligence Bureau, Research and Analysis Wing, certain officers within that, NIA, Enforcement Directorate, and so on. So I won't take too much time. But yes, there is an exhaustive list of agencies set out in the 2010 Office Memorandum who could write to the concerned agency, that is the Bureau of Immigration, for issuance of an LOC so as to restrict the movement of subjects. 2021 Office Memorandum further expanded the scope of these agencies. And as I was mentioning, one of them was Chairman, Managing Director, or Chief Executive of all public sector banks, and 2, an officer of the SFIO. So therefore, the Ministry of Corporate Affairs also was given the power to request, because more and more of these corporate frauds, corporate scams were being unearthed over a period of time, and therefore it felt the government, the Ministry of Home Affairs felt it necessary to give the power even to the Ministry of Corporate Affairs and even the chairman and managing directors of public sector banks. Of course, subject to the same safeguards that there have to be reasons and so on, which of course has been judicially evolved over a period of time. And needless to say, the criminal courts in India also have the power to request the local police authorities or any other law enforcement agencies to issue these lookout circulars. So therefore, if there is a summons issued by a court and for whatever reason, to avoid appearing before the court, this person is not appearing at all, and there is a risk of him fleeing the country, fleeing from the law enforcement altogether, the courts can also direct the local police authorities, the local SP or the commissioner, as the case may be, to write to the Bureau of Immigration to issue an LOC. So the courts will direct the investigating authorities and they will write to the Bureau of Immigration. So it's quite broad. Now, who can request for these issuance of LOCs has been at least delineated, but it is certainly quite broad in scope, and a number of authorities have been given the powers to request an issuance of LOC. Of course, it is subject to restrictions within the office memorandum itself. There are duties and liabilities of the originator/originating agency. So if the SFIO or if the ED were to request for the issuance of an LOC against a particular person, they will have to make a request in the prescribed pro forma. The prescribed pro forma must contain reasons. The prescribed pro forma, in fact, is a part of the office memorandum. So it has to contain reasons as to why it is necessary to issue a lookout circular against a certain person. And it must also, of course, needless to say, it must completely identify the person and so on, so that the wrong person is not detained at the airport or wherever, or the port, wherever is trying to leave the country. Interestingly, the office memorandum casts the liability of actions taken by immigration authorities on the originating agency. So the immigration authorities are not liable for any wrongdoings because they are only following not instructions, but they are adhering to the requests of various investigating agencies. Therefore, the office memorandum makes it clear that there is no liability on the immigration authorities, since they are only doing what somebody else is requested for. And the liability would lie on the requesting agency. Now, this has again been followed in the 2021 office memorandum as well. So that should broadly cover, of course, only touching the surface, but what an LOC is, what is the procedure for issuance of LOCs, who can request for issuance of LOCs, who an LOC can be issued against, and in what circumstances an LOC can be issued. Now we come to the all-important aspect of the remedies available to the subject of a lookout circular. In fact, that was also one of the questions framed in Sumer Singh Salkand, because at that time, as I was saying, it was largely unregulated. And in Sumer Singh Salkand, the Honorable Delhi High Court said, yeah, the subject of an LOC has two options. One is approach a competent court seeking cancellation, revocation, or quashing of the lookout circular. It did not mention under whether it should be an Article 226, or it did not go into that. It just said approach a competent court. So it left it open-ended, or write to the issuing authority seeking cancellation of the lookout circular on the ground that it has been wrongly issued. So he has two options as per Sumer Singh Sultan. But of course, after that, number of lookout circulars have been the subject matter of writ petitions where they have directly been challenged under Article 226 before various high courts. As I was saying, of course, most of them coincidentally have been in the Delhi High Court. There have been a number of judgments, even of the Karnataka High Court. But most suffice to say that a number of these LOCs have been challenged by way of writ petitions invoking Article 226. As initially, there was a certain amount of resistance from the Union of India saying that these LOCs cannot be the subject matter of judicial review under Article 226. But that contention has been emphatically negatived in all the cases without exception, saying that, of course, 226 is certainly a discretionary jurisdiction. But in Karti Chidambaram, the Honorable Madras High Court said that wherever any action infringes upon certain rights, fundamental rights or civil rights of a citizen, Article 226 can certainly be invoked to judicially review those actions. Even in the recent case, as I was saying of Vikas Chaudhary, Honorable Delhi High Court said there can never be any blanket bar on the court's power of judicial review to examine the authority's decision to issue the LOC. And in light of the adverse effects that the issuance of an LOC can have on the individual's life, the respondent's plea that the writ court under 226 should not review the decision cannot be accepted. This has also been affirmed by a recent Karnataka High Court judgment in the case of Asif Kader, as I was mentioning that earlier, where again, the Karnataka High Court has said that the normal principles of judicial review, for example, non-application of mind, no reasons, arbitrariness, and so on, are certainly grounds on which the writ jurisdiction of the high courts can be invoked to seek quashing of these lookout circulars. So I don't want to dwell too much on whether it is a subject matter of whether they can be a subject matter of judicial review, because I think very frankly the answer is yes. I don't think there can be any other view that all executive actions, as the scope of judicial review over a period of time has been enlarged so much in our country, it would be a little unwise to say that LOCs are completely beyond the pale of judicial review. But there are certain additional aspects, some of them which have not been dealt with by any courts at all, which I'd like to touch upon. One is that the moment fundamental rights are involved, and I don't think there can be any doubt right from Maneka Gandhi's case that the right to travel abroad is a fundamental right. So that has been repeatedly followed in a number of judgments. I don't think there can be any doubt on that aspect. So therefore, there are fundamental rights involved when a LOC has been issued. It necessarily restricts the person's movement outside the country. Two, it can also be said that it affects his right to livelihood. I may be a businessman who needs to go to Singapore or the US or Dubai to meet clients to earn my livelihood. It could also potentially affect my right to livelihood, once again affecting my rights under Article 21. In fact, that was also, that argument was noted and accepted in the case of Vikas Chaudhary by the Delhi High Court, that it can also affect the right to livelihood. So therefore, I don't think there can be any doubt that the issuance of an LOC and the restriction on a person's movement outside the country is a restriction on the person's fundamental rights, specifically under Article 21. As we all know, no fundamental right, even under Article 21, is not the subject matter of restrictions. Restrictions can be placed on even rights under Article 21, as very, very lucidly explained in the case of Justice K.S. Kutswami in the Aadhaar case, where Justice Chandrachud has beautifully laid out the circumstances in which restrictions can be placed, although that was vis-a-vis a right to privacy, but they can equally be applied even to other rights under Article 21. And the three important aspects which in fact, Justice Chandrachud as well as Justice Nariman in Putswami's judgment affirmed. In fact, Justice Sanjay Kishan Kaul added another aspect, but again, that's beyond the scope of this. But the three important restrictions, or not restrictions, but three important circumstances which have to be prevalent when a restriction is placed on a person's fundamental right under Article 21 is that, one, as the article itself says, Article 21, no person can be deprived of life, personal liberty, etc., except without in the manner, procedure established by law. So there has to be legality to it. The restriction has to be backed by law. I'll come to that because there are some interesting questions on that. One, there has to be legality. Two, it has to meet the legitimate interests of the state. So therefore, merely because there is a law which permits the executive or the state to restrict fundamental rights, it cannot do so unless it meets a legitimate state interest. And three, even if there is a legitimate state interest, the extent of invasion of the fundamental right must be proportional to that state interest, to the executives or to the government's interest. So therefore, simply put in three words, there has to be legality, there has to be legitimacy, in other words, there has to be a legitimate state interest, and three, there must be proportionality. Interestingly, after Putswami, no court has really gone into the validity of LOCs, and if I may say, even the validity of these office memorandums vis-a-vis these observations. As I was saying, I don't think anybody can reasonably argue that restricting a person's movement outside the country is not a restriction on his fundamental right. It is. Now that the government is restricting that person's fundamental right, is it satisfying the test of legality? That's a very, very questionable issue, because as I was saying, there is no statutory basis for any of these, for issuance of any of these LOCs. They are all grounded in office memoranda that have been issued from time to time without any statutory basis whatsoever. Therefore, if you go back to Maneka Gandhi's case and how they revisited the law laid down in A.K. Gopalan, in Maneka Gandhi's case, they said that there has to be a state-made law, which in other words, a legislation which has to set out the procedure by which a fundamental right under Article 21 can be restricted, failing which it would fall foul of Article 21. Now that is a very, very questionable issue, whether that office memorandum itself or the consequent LOC can survive the very first test laid down in Putswami. Interestingly, that issue was raised prior to Putswami. In the case of, as I was saying, in Priya Pillai, that issue was raised, but the court did not feel it necessary to go into it because on other grounds, the LOC was quashed. As I was saying, Priya Pillai, the issue was whether the petitioner was anti-national and was acting contrary to the interests of the country. And the court said the reasons forthcoming in the LOC are completely vague and the person cannot be said to be acting contrary to the national interests or being an anti-nationalist. Therefore, this issue was not gone into at all by the Delhi High Court, although that issue was raised in the contentions before the Delhi High Court. But I would think certainly that is an arguable issue. There is no statutory basis. It is not couched in any legal framework other than these executive instructions. So whether these LOCs can be issued merely on the basis of executive instructions is possibly something that some court will have to consider at some stage. Now, since these LOCs are being issued more frequently, probably sooner than later, this issue is going to be brought up before one of the high courts, if not the Supreme Court of India itself, and the courts will have to decide this issue. In fact, if I may say, in the Priya Pillai's case, the court briefly dealt with this aspect, although did not quash the office memorandum or the LOC. It said, if I may quote, for the reasons mentioned above, we accept the view of the so and so high court. it follows that under Article 21 of the Constitution, no person can be deprived of his right to travel except according to procedure established by law. It is not in dispute that no law was made by the state regulating or depriving persons of such a right. So there is, although possibly this is in obiter, there is an observation by the Delhi High Court alluding to the fact that these lookout circulars are not backed by any legislation, and therefore their validity itself is very, very questionable. Then the next aspect, of course, now if it survives the first test, the second test will have to be, does it meet any legitimate state interest? Is the restriction proportional to the state's interest, and whether the infringement is unduly restricting the person's fundamental rights? Those are questions which will have to be gone into vis-a-vis Putswami. So possibly sometime soon we may have an exposition of law on those aspects. In Rana Ayub's case, I thought I looked through the judgment, but this aspect was not gone into. Once again, the court merely went into whether there were sufficient reasons for issuance of an LOC, and the court said no. More recent, in fact, on 5th of April 2022, another LOC was subject matter of adjudication before the Punjab and Haryana High Court. And the Punjab division bench of the Punjab and Haryana High Court added another safeguard to protect the rights of citizens by saying that by not supplying a copy of the LOC at the time that person is stopped at the airport. Very, very honestly, what happens in most of these cases is the subject of the LOC may not even know that there is an LOC against him or her. He or she will reach the airport, and then there will be an immigration authority who says, sorry, you cannot leave the country because there is an LOC issued against you. The Punjab and Haryana High Court said, if you are stopping someone, you must necessarily supply a copy of the LOC to the subject at the time he or she is being stopped, and failing which it would not satisfy the tests of reasonableness, Article 14 and so on. In fact, interestingly, in that case, the Punjab and Haryana High Court even went to the extent of levying costs on the concerned investigating agency, saying that it is completely devoid of reasons and it's nothing but harassment. And so therefore, I think 1 lakh or so costs were awarded to the petitioner in that case. So in conclusion, I think we're almost at the 1 hour mark. In conclusion, what I would like to say is that these lookout circulars have been issued from the last 40 odd years, largely governed, not largely, solely governed by various executive instructions. Whether that can be done or not is possibly an issue that the courts will have to go into at some stage, whether it would satisfy the tests of laid down in Putswami as to when restrictions can be placed on fundamental rights. And then, of course, once these aspects are decided, and possibly they need to be decided because, as we have seen in the recent past, they are sometimes used indiscriminately by not just the executive authorities, but even banks to as a tool of harassment, as a tool of coercion. Sometimes banks may use it to ensure that a part of the loan is repaid. That say that, okay, LOC has to be issued. So when there are serious fundamental rights like Article 21 that are involved, I would like to conclude by saying that there is necessarily a legal framework that is required, rather than just these executive instructions which are being broadened over a period of time. And therefore, in the absence of this legislation, the courts will necessarily have to step in and ensure that there are sufficient procedural and substantive safeguards against abuse of the power of issuance of these lookout circulars. So I think on that note, I'd like to conclude and hand it back to Mr. Trivikram or Mr. Vikas. And again, thank you all for having taken the time off on a Saturday evening having listened on a fairly dry subject, but I hope I've made it as interesting as possible. Thank you.
Thank you so much.
As I say, you have made the most fertile soil of a desert.
Thank you.
And you're
And
actually
we should, one second, Mr. Vikas, my hearty welcome to Senior Advocate Kiran Jawli, sir, also.
Okay.
A very popular senior advocate who's practicing for the Honorable High Court of Karnataka. So, very warm welcome to you as well, sir. Now, I think we can take a few questions, Mr. Vikas. I also have noted down few questions.
Sure.
I've asked Mr. Kiran to unmute himself.
If you want
so
to,
that we
if
can
you
have a
want
thought.
to give a break to Mr. Vikram for a while, you
No,
can
no,
just
I'm fine.
request.
No,
We
no.
will just give you a short break so that we will ask senior advocate to also speak for a moment.
Sure, I think that's a great idea. Great.
I've asked him to unmute.
Yes. I request you to unmute yourself, sir.
Am I visible?
Yes, sir. You're visible and audible.
Thank you. Vikram has covered substantial issues in this regard. My experience has shown wherever I have questioned LOCs, the investigating body like the CBI seeking for its issuance is one aspect of the matter. And the other economic organizations seeking for issuance of LOC is another aspect of the matter. Vikram has directly brought the issue in question by saying that since it is not backed by any law, what is the legality of these proceedings? However, till today we have not come across any decision of any court going to this aspect of the matter. I wanted to exchange my thought with Vikram on the ground that should this issuance of a LOC be kept secret, or like the decision of the Honorable Supreme Court in Maneka Gandhi's case, on having issued a LOC, the party is informed that a LOC has been issued against you. If you have got anything, kindly state your objections to it. If we have to say that no person's liberty can be taken away otherwise than provided at law, then would not there be a requirement of providing the party the satisfaction on the basis of which the LOC came to be issued and permitting him to make a submission in that regard? No question, no, I have at least not come across any decision to that effect also. Correct me if I'm wrong.
Absolutely right.
But I don't think so.
No, you're absolutely right. In fact, the only, as I mentioned, the reason that April 2022 judgment of Punjab and Haryana says you give a copy of the LOC. That also, as you rightly pointed out, it is kept so secret that I'm sure in your experience.
In fact, in my client's case, he suffered. I got him an order from the Karnataka High Court to travel. He reached the Mumbai and came back home saying that no, State Bank of India has got issued a LOC. Now, but all fair. But as held in Maneka Gandhi's case, that if there are circumstances requiring issuance of an order without waiting, LOC being one of them, should post issuance an opportunity be given or not? Fairness.
Correct.
Secondly, I am given to understand that some petitions are pending before the Bombay High Court, contending that if there is a right to issue an LOC, it has to be under the provisions of the Passport Act alone, because the Passport Act alone permits every man's going in and coming out on the basis of a document issued by Government of India. So control ought to also be under the provisions of the Passport Act. Not reached any finality, but matters are pending. This is what I wanted to add.
No, absolutely right. So in fact, that Passport Act issue which you just highlighted, that also was raised in that Priya Pillai's case. I'll just share that judgment with you. So that there also it said that, listen, if there is already a statutory framework to restrict a person's movement, you follow that. Whereas this LOC thing which you're doing outside the scope of what is already statutorily prescribed. So possibly that is one of the arguments before the Bombay High Court also.
Now, I think post-vacation, it should be coming up here
Yes,
with
yes.
my matter in the matter of State Bank of India. Let us see what reaction the court of Karnataka would come about with.
Right.
Thank you, Vikram. Thank you.
Thank you, sir. Thank you
Thank
for
you, sir.
joining.
Thank you. We would like to see you on the other side of the panel, sir, very soon.
Sure. We shall also.
Vikram, it was a pleasure hearing Mr. Kiran Javli, and I will ask you to share the number. We will ask him, because as they say that if you have knowledge, in a minute you can share and show that you actually have the knowledge. Just like in the law, we say that the opening statement, what you make in the court, makes the mark of the case. Within the minute, you can actually catch the attention of the court, or you can feel that the court is seeing that you are aware of the making of the submissions. So we will request Mr. Kiran also to share his knowledge on the platform. And we are enamored by the fact that he has shared his knowledge. Meanwhile, can a magistrate court, I will request Mr. Kiran also to share his inputs while Vikram is inputting. Can a magistrate court pass a direction to SP to revoke LOC that SP originated that has served its purpose, like the investigation?
I would think the answer is yes, because if the direction
Against the accused person has finished.
Yes, I would think the answer is yes, because if originally the magistrate directed the investigating agency or the local SP or whoever to request for issuance of LOC, and for whatever reason the court feels that he or she is participating in the trial and not acting in any evasive manner, certainly he can request for withdrawal of it as well. Because as I was saying, in the 2021 office memorandum, there is no time duration. So that will go on in perpetuity. Unless there is actually an official revocation, that will go on and on. So it will necessarily have to be done, in my opinion.
So what is your take?
There is one decision of the Supreme Court in the case of, I don't know, the respondent was Dawood Ibrahim, wherein the Supreme Court has said that summons cannot be issued at the instance of the investigating authority to be an aid in investigation. If that principle is to be applied, making of an application to the magistrate for restraint and the magistrate issuing that order, the legality itself may become questionable. Under what authority of law can the magistrate issue it? Because he has to act on the four corners of the law. If the LOC issuance is under the basis of an office memorandum, can the magistrate act on an office memorandum? That, in my view, would be a little beyond the action of the respondent, of the magistrate.
Vikram, what is your question? You said that you have also jotted down.
I have a couple of questions. Of course, few aspects were touched by Mr. Vikram. One is the bias has not been challenged in any of these cases. So that is the first one. Second one is in context to the matrimonial issues, how would it work? Because most of the time there could be an order for maintenance, but the wife is unable to get any maintenance because the husband is outside, or sometimes he is trying to fly away. So in these circumstances, is there any, could you just...
In my opinion, again, unless one of these investigating agencies are seized of the matter and they request for issuance of the LOC, it can't be done at the behest of a private party, certainly not. So if the wife wants to prevent the husband from leaving, I don't think, and thankfully, otherwise it'll be opening up the floodgates even more.
Yeah.
So when we are appearing for the wife, then it becomes difficult to get it executed. So rights are infringed when the scale has to be balanced.
You can make an application to the court directing that the passport officer be directed to suspend his passport and thereby create a situation where his continued stay abroad may become difficult in view of his invalid passport or suspended passport. That is the maximum that legalistically, in my view, that can be done.
But how will our
revoking the passport?
how well our judicial officers are equipped is also the question, sir. They should be trained rigorously on these aspects as well.
We can't blame them for that, for the reason that these issues, some of which that we are discussing here, have never come up as a routine matter before that. They are tired by the time they at 1 o'clock in the afternoon by writing the order sheet. You see, you must understand their practical difficulties also. There are so many subjects. Many of us lawyers don't know that there is an existence of such a law. And I have come across that a number of times because most of my subjects are not even available or known to everybody. So making submissions on some of the matters where the long forms are also not known, and I on a regular basis keep citing them. So I would not, the magistrates in a special court may be trained. Now, in view of the fact that number of special courts for every aspect of the matters are being set up, in those circumstances, I think the Judicial Academy will have to train them with the existence or bring it to their knowledge the existence of such laws.
Mr. Vikas, I just see in the messages on the chat box, there's one Mr. Yashvardhan who said, I have appeared in the Punjab High Court matter. He wants to share his views. So I just noticed on the chat box that message is there.
Before he is unmuted, Mr. Vikram, I have the small question.
Right.
You were touching, you in fact mentioned that we should have a legal backup.
Person is not unmuting himself. Yeah, he is done.
All right.
With one question there, meanwhile, if Yashvardhan doesn't, can investigation officer enter into anyone's house without making an entry of the arrival and departure
After registration.
in the daily diary report after registration of FIR?
That has nothing to do with this thing, but I mean that has to be governed by provisional CRPC. This has nothing to do with whether he can enter anyone's house without making an entry of arrival or so and so. That general procedures under CRPC safeguards will have to be followed.
Are heads of private sector banks also authorized to make a request for LOC?
Not private sector, not as of now. The provision very clearly says only public sector banks.
Yashvardhan, if you can share your knowledge, what were you saying? Yeah, Vikram, meanwhile, you can take your question.
All right. My simple question was, we don't have a statutory backup. You have already mentioned it, but don't you feel that we need to have it very soon? Because since since decades that we are still acting upon the executive orders. It's high time that we need to have a statutory backup.
I totally agree. I think Mr. Jabli also will agree that in the absence of this of a statute, now as we have seen, despite so many safeguards under all these penal laws, including our CRPC, there are still investigating authorities who act in the most high-handed manner. So in the absence of that, you can imagine how arbitrary their actions can get. I'm not saying they all do it. In the absence of a statutory framework which is why Article 21 says it has to be procedure established by law, and it has to be a state-made law. It can't be by way of executive instructions, in my opinion. It's in dire need.
Yashvardhan has said that he's been unable to unmute. I think.
Hi, everyone. Thanks, Vikram sir, for a very thorough and detailed overview of the law. So this matter that you were referring to in the Punjab and Haryana High Court, 5th of April, it was decided. This matter then went before the Supreme Court, which was the matter was represented by me in the Supreme Court. And on the 5th of May, the court has issued notice in the matter. While it has allowed that particular person, Noor Paul, who was the petitioner before the Punjab and Haryana High Court, they have allowed her to travel, but with regard to the law, they have stayed the directions of the court. That matter is going to come up after vacations, and the union will file its reply, and the court will consider the legal issues in detail. This is the bench before Justice Indira Banerjee and A.S. Bopanna.
Fantastic. Thanks for sharing that. But I was wondering why none of these cases actually go all the way to the Supreme Court. And finally, Supreme Court will have to lay down the law. So good luck, and
Thanks.
hopefully you'll have some good news.
Yes.
So there's one more question. It says, sorry.
Again, regarding the 1 year, I just saw some message popping up.
Review of LOC mandatory. Yes, subject to correction, the office memorandum does say that there has to be an annual review. So that automatic lapsing doesn't happen, but there has to be an annual review is what the office memorandum requires.
But who would do that review?
By the invest, because it's more a request to the Bureau of Immigration to issue this LOC. So the investigating authority will have to review the facts and circumstances and see whether it is still necessary for this LOC to be kept in force. So it will necessarily have to be the same authority.
I think we have touched all the questions. I request the details of the recent OM, please.
That's what I'm saying. The recent OM in 2021 only adds these public sector banks. That's a major departure from the previous position. And also the 2017 one says economic interest, larger public interest, and so on. So those are the major changes. Otherwise, most of them are procedural in nature, which says that the pro forma, the new pro forma reasons have to be given and so on. So there's nothing substantive changes other than these two. And of course, the duration of LOC has now been done away with, that 1 year duration.
All from my end.
Can LOC be suspended for a brief period, say 1 month or 2?
It can be. Then you're literally at the mercy of the concerned agency, because by suspending the LOC for a month, you're essentially allowing that person to travel. But then the moment he leaves, that sort of defeats your purpose. The whole reason of the whole purpose for issuing the LOC was to make sure he doesn't leave the shores. So if you suspend it for a month and he or she leaves the country, in fact, one of the Delhi High Court orders I was referring to, Brij Bhushan, the Delhi High Court said suspended. It was not a final order, an interim order suspending the validity of the LOC, permitting the person to travel abroad, whichever country he or she was going to, and subject to the condition that every 2 weeks that person reports to the Indian embassy. So every second Sunday, he or she has to go to the Indian embassy in that country. I'm forgetting which country it was. So yes, it can be suspended by the courts. It can be suspended by the investigating officer as well.
Judgment of what you were referring of Punjab, and I was just checking it on the law finder. That is Noor Paul versus Union of India.
Right.
Yeah. So thank you, friends, for connecting with us. And tomorrow session will be, he has already come on our platform, and his sessions, as you all know, they are doing tremendously well. Tomorrow would be suit for specific performance of a contract, pleadings, reliefs, and distribution by Mr. K. Prabhakar from Madurai Bench, Madras. So do stay connected with us tomorrow at 6 p.m. And thank you, everyone. Stay safe, stay blessed. And Vikram, it was a pleasure hearing you.
Thank you.
Thank you, Vikram sir, for a repeating presentation. Thank you, Vikas sir. Thank you so much.
Thank you.
Thank you, participants. Thank you, Kiran Javli sir.
Thank you, Javli sir. Thank you for joining.
Thank you, Kiran.